Well, hello, everybody. My name is Misty Delgado, and I am from Relivar Home Care and Alivity Care Advocates. We are excited today to talk to Charlene Distler. Hello, Charlene.
Morning.
About guardianship. So we're going to be working through unraveling the mystery of guardianship and what you need to know about it. But before we get there, I just wanted to give you a little bit of information about Relivar and Alivity Care Advocates. If you are worried, stressed, or overwhelmed about your loved one, maybe an aging parent or a friend that is struggling at home and need a little bit of help, we can help with providing private duty home care or professional care management. You can call us here at the office, and we can do an assessment within typically 24 to 48 hours and start care shortly thereafter. But today on guardianship, we do on occasion have to work with our families and talk about the guardianship program. And we have Charlene, who has her own guardianship company, and we're excited to have her today because she is probably the go-to person in Macomb County and really in the state of Michigan to talk about the guardianship program. So Charlene, thank you for joining us.
Oh, thank you for having me. I love any opportunity to educate the public on this very diverse topic.
And it can be a stressful topic as well.
Very stressful.
So
Very.
before we get too far into it, can you tell us a little bit about your company and how you started it and, what all services that you provide? Because you provide more than guardianship, but if you could tell us a little bit about that, that would be great.
Today's focus is on guardianship, and it's a very important topic. So I'll kind of focus on that. When powers of attorney fail, or when people don't have powers of attorney, that's when the court normally will be dragged into your life and change your life significantly. So guardianship and those kind of services related to the probate court, or what probate support services performs. My calling is to do public guardianship. We're very well versed in it. I've been doing this for 27 years. I love what I do. I have a staff that's incredibly gifted and trained, and all of them, we all genuinely, everybody involved in public guardianship is genuinely concerned about their fellow man. I think guardianship's been getting a bad rap lately, but we'll go into that today. My company is essentially serves public administrators and attorneys that do estate planning, Medicaid planning, especially, and special needs trusts, those kind of things. They're all probate related. And a lot of times we'll have cases that are very complicated where they're all intertwined. So that's it in a nutshell. That's not what guardianship is, but that's what our company does.
Right. And so if we can maybe start unraveling the guardianship a little bit for families, do you want to help us explain what is guardianship?
Guardianship is when legal evidence has been presented to a judge that is very concrete and proves to the judge that criteria have been met to deem a person legally incompetent. There are degrees to that. You can have a limited guardianship. You can ask the judge to limit what the powers of a guardian are. In families where guardianship is needed, there's usually a wide berth given. When public guardians, public fiduciaries are appointed, there's a delineation in the law of what we are charged to do by law and what we need to do. So guardianship is the care and custody of another human being. It's incredibly important work when you stand in the footsteps of another and try and advocate for them and make their life as best as possible. So there are a lot of dynamics that go into guardianship. You have family dynamics, you have the law now entering your life. family relationships, financial matters, placement, medications, all of those things are rolled up into guardianship. Anything to do with the care and custody of another human being when no one else is there to speak for them. I think one of the things that people don't understand about public guardians, we're number 10 on the list of appointments. Number 10. So by the time the judge gets to us, they've normally exhausted family and powers of attorney and other things that are going on in this person's life. A lot of times families are exhausted with someone who is mentally ill and non-med compliant. So the judge will, if nothing else, to give the family a rest, appoint a public guardian. Again, it's the care and custody of another human being.
Okay. And it can be a very difficult job emotionally.
Emotionally, and I think that's what most lay people don't understand, that
Right.
there's a lot of emotion working.
Mhm.
And especially if you have diametrically opposed family members that don't really agree with the process or agree with decisions that are being made, it becomes pretty volatile. So
Typically, what is the determining factor for, I mean, how does the judge actually decide that the individual needs a guardian? What things are they looking for?
someone will file a petition for the appointment of a guardian, and that kicks in a whole protocol. The petition has to be accompanied by a doctor's letter, wherein the doctor declares that the person cannot make informed consent, cannot make informed decisions. They don't have the wherewithal. They've either suffered a stroke or had a massive heart attack. A lot of times we get appointed when someone's on a vent and the hospital comes to us and says, this person cannot speak for themselves, we cannot find family, and we need to go in and do a procedure. So, we need somebody to sign off on that. So those are the emergency guardianships. The alternatives to guardianship are something that are discussed. So going back, so there's medical evidence presented to the judge that this person cannot make informed consent, informed decisions. They don't have the wherewithal. They lack the mental capacity to make decisions about their care. When families are fighting, hospitals don't want to put up with that, and they'll go petition the court for guardianship so that a disinterested third party can make those decisions. And anybody that is a guardian, that's a fiduciary position. When you are a fiduciary, you are called to a much, much, much higher standard of care than a husband and wife might share, or a son and a father, for instance. That's between family members. But once the court is involved, there's a much higher standard of care that's expected. That's one of the reasons guardianship and conservatorships get expensive. And people really need to be cautioned against that. It's an expensive process. So you want to look to alternatives to guardianship first and foremost.
When you say a fiduciary, because some of our folks listening to this won't understand, what does that mean? A fiduciary?
In law, the state of Michigan has enacted the fiduciary standards. Those list right in the law what a fiduciary needs to do. You're called to a higher standard. So in other words, is the typical case that I would get appointed on would be a gentleman or woman in a nursing home who has no family or no family willing to act. They're usually estranged from one another. And it is my job. They probably only have Social Security income. So it is my job to assure the court that every penny that I collect of Social Security is spent on the individual. Sometimes I have to be bonded, which is a separate insurance policy. I am vetted with the court. I have to show them all my insurance policies. I'm called to a higher degree of care. I am called to inform family, whether they want to be informed or not, that this is the care that we're providing for their loved one. So fiduciary capacity, whether you're a financial advisor, whether you're a trustee, there are higher duties than just like that a father and daughter would share, or a husband and wife. And we have to document everything. Everything we do has to be documented.
Right, kind of an explanation of why you did what you did.
Exactly.
Yeah, you'll explain it. So you had said there are other alternatives, guardianship, guardianship being, should be your last resort. What are some of those?
The most common one that people know about are powers of attorney. And let's talk about the three top ones. Medical power of attorney, of course, deals with anything that's medical in nature. Then there's the financial power of attorney, which gives that fiduciary control of any financial matters on behalf of the person that's incapacitated. And then there's a durable power of attorney. Sometimes that's a combination of both. We don't see them too often, but a long time ago, they used to combine medical and financial all into one. So these are a wonderful, wonderful mechanism. Everyone should have one. From the time you turn 18 on, everyone should have one. And you should review them often. And if you have a question, you need to seek out an attorney. My documents, I have them reviewed with an attorney every 3 years. There's new language. About 3 years ago, there was new mental health language that was included. And so if your power of attorney doesn't include language about mental health, you probably need to have that updated. When we look to alternatives, a lot of times there are programs sponsored through the government, like the PACE program. And the PACE program is designed to keep people, it's either 50 or 55 years older. They qualify for Medicaid, and they need that supplemental assistance. So the folks in PACE actually go to the home, pick people up, take them to the center. They're given meals, their medical care is given there, their socialization. As people age, isolation is the one thing I see that advances dementia and just sheer loneliness on a accelerated basis. So PACE has incorporated a lot of different elements. It's a good program, that's an alternative to guardianship. Another alternative is waiver money. So let's say you have a stroke, you're in the hospital, and then they discharge you to a rehab facility, and it's apparent that you can't go home, but you're indigent. If you qualify for Medicaid, you're in the hospital, they want to discharge you to a rehab facility, and then from rehab, you're going to assisted living and not going home because you just can't afford the care. Then you would want to look for waiver money. And again, you would work with the social workers at the discharge level with the nursing home to make sure that waiver money is in place so that you can go to an assisted living facility. Or in the alternative, we work with Olivity and Relevar quite often. They're incredible. The oversight that they give to our people, I can't say enough about the wonderful care that they provide. And if you're confused about things, Olivity is a wonderful product you should probably think about using. They give you alternatives as well. So, there's help, there's assistance. You just need to know where to look for it.
No, I appreciate that, Charlene, and we try and do our best all the time to get families through different processes. Every family member, a lot of times they'll say to me that they, oh, you've probably seen this before. And I'm like, no, not really. Every situation, you know that too, right? I mean, every situation that crosses our desk might have similarities, but there are differences as well. And always trying to help guide people to talk to the professionals. You know, for example, if they were looking for a guardian, a professional guardian, to speak to a professional guardian before taking that task on themselves, because there's some pros and cons with that, and we'll get to that a little bit later. But so what you're saying is really looking for alternatives to being a guardian is really important. If the individual is incapacitated, though, does ultimately it come down to, let's say, for example, I'm going to use an example, a recent example that we got into, which was the individual had some cognitive impairment. It wasn't too bad. But although they had been taken advantage of by a private caregiver, when a stepson realized what was going on, he stepped in and is now filing for guardianship because this particular caregiver is still going to the home, even though things have been corrected in this situation. Financially, she had her name on house, 401ks, other things, because nobody was overseeing the situation, and the elderly person trusted her, and she had made commitments over time. So in this particular situation where he's trying to get her from going to the home versus, she's still going in there now that everything's been changed around, and the client themselves love her. Is there any other alternatives to guardianship to take over that guardianship and basically file to have her not return to the home? Because this is a situation we got into.
Yeah. And we're seeing more and more of that all the time. We saw a post lady, who was asked in our elder, was partially blind. And so she asked the post lady to come in and read her mail to her. And the next thing you know, she had her name on everything. So
Right.
these are things that we see all the time.
Right.
There are advantages and disadvantages to guardianship and conservatorship. Conservatorship is the end all be all financially. Everybody has to listen to a conservator. Any powers of attorney that you've drafted can be revoked by the individual at any time. So let's go back to your original scenario where the person had limited capacity. As long as they are understanding what it is that's being asked of them, and they have not been coerced or undue influence has been exerted, these are things that can be worked out with a power of attorney. And because you want to be really careful. Once the court's involved in your life, there is a lot of paperwork, especially with the conservatorship. So you want to think that through. But there are times when you have these, and I call them drop dead situations, where you've got a postal lady taking financial advantage. You need the power. You need the courts behind you. The court empowers you to act on their behalf, and you need to go get that person's money back and vest it where it's protected. So a lot of times there is good reason to come forward and seek guardianship and conservatorship. So with a guardianship, you have the care and custody of the person. With conservatorship, you have the care and custody of their money, their assets. And so a lot of times one goes hand in hand with the other. You may have to revoke a power of attorney, and guardianship allows you to do that. And so there's a lot of dynamics. And before you want to do any of that, I suggest you go see an attorney that specializes in guardianship and conservatorship probate work. And just lay out the options on the table and figure out a strategy. So,
That's a really good tip.
yeah, it can be daunting.
Yeah. So how does an individual become a guardian then? Let's say we've decided we are going to become a guardian, and what does that look like?
So you're going to secure a letter from the doctor that says the person is incapacitated or has limits should be placed on what the guardian can do. Because you can have limited guardianships. The doctor will provide you a letter. You can on your own or with an attorney assistance, fill out, there's a packet that each court has for the petition for guardianship. You fill out paperwork. It's accompanied by the doctor's letter. You pay a fee of $175. The guardianship hearing is set, and most of the counties nowadays are 30 days. They're back to a 30-day hearing date. During that time, the court appoints a guardian ad litem. The guardian ad litem is usually either an extremely well-seasoned attorney that has lots of years of experience doing this when things are complicated. And you can tell by reading the petition what you get a pretty good grasp of what's going on. And so if the court feels they need to appoint someone with experience, especially in a particular area, like say one of the people involved is developmentally disabled, and it takes a certain finesse to be able to work with folks. So they'll appoint a guardian ad litem. Sometimes they're brand new attorneys right out of law school, which is always neat because they have fresh eyes, right? And they have fresh energy. So it's always a good thing. We've got this mix of dynamics that goes on. So that guardian ad litem interviews the person, and then they interview all the other parties that are involved, and they report back to the judge in a written report, and they recommend whether that person, yes, lacks capacity or no, they really, there need to be limits placed on the guardian. And so the hearing is set out in 30 days. It is the responsibility of the petitioner to send all the documents out to interested parties. And in guardianship, it is the one area in law where the Good Samaritan can step forward and file a petition. In all other petitions that I know of, you have to have what's called standing to bring a petition. But this is where the Good Samaritan rule comes in. If you feel that your neighbor is having undue influence or someone's exerting pressure on them to do something that you know they would never do, you can come forward and file a petition for guardianship in the court. And then the court will appoint somebody to go out and investigate. So there are checks and balances built into our Good Samaritan rules, and it's a wonderful thing, wonderful thing. So then we have the hearing. The judge listens to all the parties, and then with clear and convincing evidence, then they issue their opinion as to whether a guardianship should be created and whether that guardian should have limits placed on them. So for instance, I have a guardianship where before I make before I move the individual, I have to come back to the court and explain to them why I want to move them. So if they're going from assisted living to a nursing home, let's say, I have to ask the court's permission. I can't just move them. At some point in time in the proceedings, the judge was convinced that this person had a very genuine fear of nursing homes and didn't want to be placed in a nursing home, even though they may have needed a greater degree of care. So, the judge queries me like, can't we just bring more help in? And then I have to present the proof that says the facility that they are at cannot provide the care that they need. And so it is necessary for them to go to a nursing home for that care. and more skilled care. So anyway, there are limits that can be placed on guardians. And that's always in the back of my mind, because I want to do what's in the best interests of my individuals, and I always want to do what's best for them. And whatever it is they need, that's what I want to provide for them. So.
And you're a very compassionate individual, because most other people would call them, and I'm not a fan of the word, which is a ward, like a
Right.
ward. And so you're calling them, individuals, and that says a lot. What can I just ask you, while we're on the limited guardianship, what other types of limits could an guardian get? What are they?
A lot of times cases will come to the attention of the court because one family thinks there's undue influence going on, because someone's isolated mom, right? And the rest of the siblings can't see mom. So the court will order a visitation schedule, medication issues. I might, you can't have electroshock therapy unless the judge allows you. So if someone's severely mentally ill and the doctor recommends that I do electroshock therapy, I'm going to the court to get the court's blessing. It's not going to happen until all the parties have come to the table and we've had a discussion and the judge is convinced that that is the best thing for the person. So, I know if somebody wants to get married, I would go to the court and ask for permission. When you have a guardian, you cannot carry arms. There's a suspension of that right. You are not allowed to own firearms, and you cannot marry without permission of the judge. So those are they're big things, they're big things. So
yeah, good tidbit. Thank you for that. And I think you've already answered the who can file for guardianship. It sounds like the Good Samaritan is anybody.
Anybody. And right, we as a society want to care for one another. We want to make sure that our neighbors are taken care of and not abused. And it's become painfully obvious to me, especially lately since COVID. People, as they age, especially if they're isolated by family members, they become very frightened and very dependent on the person that's doing the isolating.
Yes.
And they make such irrational decisions. And you think, wow, how could this strong person, they owned their own company, they owned, they were so successful in life, and here they are cowering in the corner because the person that they depend on most, right? Who's giving their medications, who's bathing them, who's taking them to the toilet. And all of a sudden, oh, wait a minute, this person's going to be ripped out of my life. What's going to happen to me? And nobody's taking the time to explain it to them, right? And so it's daunting for them. It's very daunting. So there are a lot of dynamics that you have to take into account.
Yeah.
But
that's a big one. The last two clients we worked with in care management, they were really fearful of losing their caregiver, even though there was abuse situations involved.
Yeah.
They just need to know, provide comfort that there's other people out there that care for them and are going to take care of them the way they want to be cared for. So, duties and responsibilities, that's a big one.
It is, but in my mind, it boils down to how do you want to be treated, right? Is it with dignity and respect? And that's, of course, the basis. The National Guardianship Association has defined 31 best practices. And if you go to the National Guardianship Association website, you'll see the 31 delineated out there. But it starts with the respect, dignity, and integrity that you would want to be treated with. my duty to the court is anytime somebody moves, I need to make the court informed of where they've been moved to. Annually, I do a report to the court. It's a 3-page written report about the medications, the medical care that they've received. Socially, what are they up to? Are they participating? Are they self-isolating? Was there something traumatic that happened? How often does family visit? Was supervised visitation ordered? And if so, was that order followed? Sometimes children don't know how to visit with their parents. They go in and they just agitate them to no end. And so, I've only had to do it twice. I asked the court for supervised visitation when the family was present, that one of my staff had to be there. And the minute they started exerting undue influence, they were asked to leave. So yes, it happens. But normally if you sit down and speak with family members and say, this is when you visit with mom, we're going to talk about uplifting things. We're going to talk about raising her spirit. We're going to talk about things that inspire her to want to live and get better. And we don't talk about money, and we don't talk about the things that agitate her. And it always dumbfounds me that you've actually got to outline that to family, but I do. When I tell you we're 10th on the list of appointment that tells you how the family situation has deteriorated,
Right.
and how the deterioration is harmful to a human being, an elder or someone who's disabled. So these are the things that I take very seriously. So I have, anytime something major happens, I go right to the court and I get the court's interpretation or permission. And I have the annual report that's due to the court once a year. And I do that report. The court scrutinizes it. If I'm approved again, then they update my letters of guardianship for another year. I mail that annual report out to all of the blood relatives and anybody else that's an interested party. And then they have time to call me and say, wait a minute, this is not my understanding of what was supposed to occur. So we have a conversation. And if they decide that that's not appropriate, they have the right always to go to court, always, and to have the matter heard. So I had a gentleman that I was caring for. He was in a nursing home. And one of his daughters was an aide in the nursing home. We got a call. They were running him to the hospital. He was having an anaphylactic reaction to something. And they didn't know what, they couldn't. So there were 11 children altogether. None of them got along with one another. So we went through this litany of phone calls about let dad die, let dad, don't hook him up to any machines. It's time, he's 88. It's time to go. It's time to go. And I prayed over it and I thought, wow, I don't want him suffering. He and I had conversations about him not being hooked up to machines. Well, the young daughter that was a nurse's aide called me and she goes, don't you dare unplug him. He'll be fine. He's going to come through this. And there was something so genuine about her words, and she sees him every day because she works every day with him. Right. So I prayed over it and I thought, no, wait, we are not going to unhook him. We'll see. Well, third day he wakes up bright as a penny. He had allergic reaction to a new medication that somehow didn't get charted at the nursing home. And in 3 days he was fine, and back home he went, back home he went. So, a lot of times there's a lot of gut work going on, trying to figure out what the family dynamics are. So that was a good ending. That one was a really good ending.
It just shows you really the difficult, decisions you have to make for an individual. It's big. So,
End of life is something that people need to spend more time talking about. I can't tell you how many powers of attorney. Oh, yeah, my dad's got a power of attorney. Can I see it, please? Nothing's checked. Nothing's decided. Nothing's
right.
notated.
Yeah,
Nothing's initialed. Yeah, I'll make those decisions yesterday and it never happens. And I have no directive. I have no idea what they want. None.
yeah.
Until they become conscious again and I can sit down and talk to them. So please get your powers of attorney and do them. Check off those check boxes. Write down what you want. I'll tell you a quick little story. We did our estate planning and my husband told me, he goes, I will never unhook you ever. And I go, I will haunt you. I will haunt you. So my sister is my power of attorney because she said, I'll pull the plug. I'll pull the plug. So my
Well,
sister is my healthcare power of attorney.
that's really important to have that conversation because there's going to be people that can't do it and you don't want them making that decision. I had that recently with a neighbor who had it made it clear with her family that if she went on an event, she didn't want to go on an event. And they put her on an event and then she did, you know, so many people today are coming off vents and still living productive lives, but she did not want to. And she still cries to this day, 2 years later, that she had, you know, entrusted them to not put her on the vent. And, you know, so it's very important who you choose.
Yes. Yeah, they have to be able to execute. And my husband and I and her had a very long conversation so that it's delineated out. You know, if I have a stroke
Mhm.
and I go on an event, but the doctors say there's, you know, I'll bounce back and not worry about it, then that's a different situation than having pneumonia and paralysis and all of the other things that we see on a regular basis.
Sure. Yeah,
Just let me go.
that's
Let me
right.
go.
Yeah. And now, so when you say that these are the things that you as a guardian need to do, these would they mirror what if I'm an individual and I'm taking care of my neighbor and I'm now their guardian, I have to do these same things, these same reports, have these same limits put on me as what you would?
Absolutely.
Okay.
The law doesn't, you know, law doesn't discriminate against a layperson or a professional.
Okay.
The rules are the same. The rules are the same. You once named, you become a fiduciary and you have that fiduciary duty to treat the person with dignity, integrity, and respect. You make wise decisions, you listen to the individual, and you advocate for what they want.
Mhm. And then you have to go back to the court yearly to get confirmation that you're still their guardian. Is that
Yes.
correct? Okay.
Yep.
And you have to write a report.
Mm-hmm. It's a lengthy report. They want to know what medications you're on. They want to know what doctors that have been seen. They want to know if the person's self-isolating. Are they social? Are they kind of hermit or nerdy kind of people? What are you doing to make sure that they have a good life? That it's a long 3-page report to the court about what that person is, what's going on in that person's life. So.
And just because I'm a guardian doesn't mean actually that I handle their money. I might be having to go to somebody else, like to get, you know, briefs or protein drinks or whatever I need to get for them.
Yes. The person, you might have the situation where you've become guardian, but somebody else's financial power of attorney or conservator, and they have control of all money and assets. You do not. So you're a team and you work toward the best interests of the individual.
I have down here, what is the process for guardianship, but I think you've already kind of outlined it. Going to the website or working through a professional would really be preferred so that you know the steps that you're taking would be best.
Yeah, there are a lot of steps. You don't want to have a misstep because if something happens, they'll adjourn the hearing after if you're waiting 30 days for a hearing, then you're going to wait another 30 days to correct that error. And there are so many nuances and so so many little things that can go wrong. So you really want to seek the advice of a professional.
What kinds of things then, Charlene, since you brought it up, can go wrong in this scenario?
The person that's coming under guardianship may want to object. They may not know that they can ask for a court-appointed attorney to represent them. They may not know, they may not remember that they have a power of attorney, stuffed in the top drawer of the china cabinet kind of thing. And these are things that keep the court out of your life. If you have already executed a power of attorney, but you didn't know that, you didn't tell that power of attorney, you didn't give them a copy of the document. And so there's going to be a fight between the guardian and the power of attorney as to who's and whether a guardianship is necessary then. Can that power of attorney step up and do all the things that essentially a guardian is going to do, but it keeps the court out of your life? So there are parts of the process. So if the individual wants to object, okay, what does that mean? First, we look at the individual. Do the professionals all really feel, I mean, the doctor's not going to write a letter and jeopardize his standing and reputation. He's a doctor. He's legally bound by his ethics. You can't say a person needs a guardian if they don't. So capacity is one of those things that is a gray area. The finest days are when we've especially had people who have had strokes, and a year later I can go to the court and say, terminate this guardianship. This person's made a recovery. She's fine. She's back out on her own, living independently, and no need for a guardian. So there are tests, an independent medical evaluation by a psychologist or psychiatrist might help determine capacity. So then you've got, the original letter you had might be from the emergency doctor in the hospital. And now that this person's had 30 days to recover, say they had a slight stroke, and an independent medical eval then can be presented, and the judge would be convinced, okay, this person's recovered, and we can dismiss the guardianship. So there are a lot of different nuances that go on. A lot of times you get family fighting, right? And that's the biggest dynamic when siblings start fighting. So everybody's hiring an attorney, and the next thing you know, there's lots of dynamics going on. So every single document that you have in that packet, the initial packet, has its own reason for standing on its own. And there are nuances that are involved in each one of those documents, the way they're filled out, the way they're processed. It's all important. It's all important.
We have a scenario right now where a client has two psychologists who have done neurological testing to determine the individual incapacitated, but we have another psychologist fighting it. So, it's interesting. It's going to be interesting to see how that plays out. And that kind of leads a little bit to cost.
Whenever there's litigation within a guardianship or conservatorship account, you're looking at between $20,000 and $40,000 to litigate it all the way through. So I think one of the things that I'm proudest of, especially in the community where we are, a lot of the top-notch professional, the attorneys, the professionals, we all sit down in a conference room together and we hammer out a resolution if we can. I was part of one last night. Remarkable talents. Two attorneys explaining what the alternative is, so that if the parties decided to go forward and fight this out, they're looking at $40,000 in fees on both sides. And there's not going to be anything left to take care of the individual. And so at that point, we're all looking at, the families are looking at each other going, no, wait a minute, this money's supposed to be for the individual. Let's find a solution. So one was hammered out. Not everybody was happy. Neither side was happy, but they ultimately were able to put that aside and look at what they were being able to do for the individual. So it gets expensive. If you go into court yourself, it's $175 to file the guardianship. If the person has more than $5,000 in assets, normally the court's going to force you to file for conservatorship as well, and that's $175. And then if things get ugly and you have to hire counsel, then that's when it gets really expensive. So.
Can it be revoked or transferred? I'm a guardian. I'm, not able to do this anymore. I'm headed to Cancun for the rest of the winter or whatever's happening.
Yeah.
What do we do here? Even legacy issues, right?
Yeah.
Who's going to take over when I die?
Yeah. When a person, especially we celebrate those times when a person bounces back, right? They've had a stroke, they're better, everything. Yeah, we petition to terminate the guardianship. You can also petition to limit the guardian's abilities to do anything. And you can also petition to terminate at any time. So if a individual gets well, let's terminate. The guardianship's not needed anymore. If we need to change the dynamics, like say, I'm guardian for my son and I'm, now 86, 87 years old and I just can't do this anymore, right? He lives in an adult foster care home, let's say. Those are things where you say, okay, is a family member taking over? And a lot of times people are busy. They don't want to take care of their mentally ill siblings. So you can ask for a public guardian to take that duty over. So there is legacy built in. There are always going to be people that will be able to take care of another human being, but planning is key in these areas. We children that have Down syndrome or are autistic. Those are the hardest parents to work with. They just hold on to that control. They just hold on, and I would encourage them. Because sometimes these programs take years to get into, years. And the transition should be slow so that these individuals don't panic, don't become vexed, don't become anxiety ridden. So you want that transition to be slow. Like say they're living with mom and dad and, one day mom and dad are going to pass away. So we want to get them into an adult foster care home, a good placement. It takes years, 4 or 5 year waiting lists. So you need to start planning. You need to plan ahead of time and don't stick your head in the sand about what's going to happen in the future. Just breaks my heart, these cases when we're called in when mom's passed away, dad predeceased a long time ago, and now this adult child is just acting out horribly. And nobody knows how to take care of them or what to do. So then a public guardian is usually called in and we work at that transition. So it's very rewarding work, incredibly satisfying work that at the end of the day, when I lay my head down on my pillow, I know I've made life better for some people, whether they realize it or not. It's good work. It's good work.
It's a mission. It's your mission field.
Yes, it is my mission. God told me I was going to do it.
And
I haven't got a choice.
Me too. I think we have to really touch on that, what you just said, which is we are trying to avoid a crisis because with it comes a crisis, we have limited options where we can put individuals. And I spend a fair amount of time, and I know you do too, finding good placement. But good placement, i.e., in a group home, adult foster care home, assisted living, those take time. It takes time to research them because they change all the time. Management changes all the time. Ownership changes all the time. So even though I might have visited a place a year ago, today it might not be the same, run by the same organization. And I want to also give an example of an individual we had very similar to what you're saying. She had a mental impairment. She was with a family, not her own family. She had been adopted, and her mother got sick. Her adopted mom got sick, and the family moved her mom with her into a memory care unit. Now, she didn't have memory care issues. I'm telling you, if you saw the picture of her when she moved in and the picture of her when she came out of there, you would say the degradation of her overall health was tremendous.
Yeah.
We were able to find a good group home for her to move in and put her back on the path of, mental health. But, again, we talk about time, planning early, taking the slow process, I say, eat the elephant in little bites. Let's just start this process and get it moving so that you can lay your head down on a pillow at night, knowing that you have a plan in place and you're not living with that internal anxiety of what's going to happen to my loved one. Does that make sense?
Absolutely. Absolutely. Yeah. I can't encourage people enough to do that. Any professional that you talk to in this field, it's time. It was time a long time ago, but we need to move now and start planning.
That's
So.
right. Anything else, Charlene, on guardianship that's not up here that maybe we should talk about before we wrap things up?
Understand that right now, there's a lot of political movement for reform in the guardianship field. And yes, there's always ways to improve every system. Public guardianship evolved all on its own without any governmental guidance, without guidance from any professional organization. Generally speaking, I will tell you the guardians that I have met are people that are usually retired nurses or social workers who genuinely want to help their fellow man. And without guidance, without education, without training, these people have stumbled their way through the last decades. And the system of guardianship, kind of public guardianship, where there's professionals involved, evolved. There was no guidebook. And so when you hear the Britney Spears stories, it tugs at your heart, and rightly so, it should. It should be cause for conversation. So I sit on the Attorney General's task force, and we're trying to help restructure the profession and make it more accessible, make it more understandable. They're complex issues. For instance, and I'll just give you a real quick example. The new law, proposed law, wants us to document everything that an individual owns and store it for them. And so a fellow guardian gave the example of a woman who, when she blows her nose, she names the tissue and she thinks it's her child. She has bags and bags and bags of used tissue. And if we were going to throw them away, she would suffer loss. So the things that we come up against every day, day in and day out, are remarkable. You can't write this stuff. So these are the things that we're trying to work out new legislation on, and do the best job that we possibly can. So if you want to know more about public guardianship, hey, give us a call and I'd be glad to discuss it with you. So.
You're the pro.
Oh, no, don't say that. No, don't say that.
And you can help guide families before they get too deep into it and realize that this was probably not the best plan, which happens quite often.
Yeah.
As we wrap up, Charlene, do you want to tell us some of the other things that you do? And
Our company does anything related to probate. We assist attorneys and trustees, personal representatives with their duties. You'll see we do decedent estate administration, which is when someone's passed away, we help them through the process. We discuss guardianship at length today. So we assist guardians, but we also serve as public guardians. And the same thing with conservatorship. Conservatorship is very confusing. It's very daunting. We have people come to us with shoe boxes and say, what did I do wrong? The court's yelling at me. I can't get it together. And we take those shoe boxes and we organize them and we show them how to put accountings together and assist them through that process, because that's a very complicated process. And so I'm very proud of the work we do with conservators. The accountings that conservators are ordered to do, or on occasion, the judge will order a guardian to do an accounting if they have Social Security funds that they're abusing, the judge wants to figure it out. So we do prepare accountings for folks. One of the new areas that we've gotten into is trust administration. We help trustees perform their duties. We also act as trustees, and our the one that I love doing the work best on is special needs trusts for our developmentally disabled folks. Just love working with them. They're wonderful people. They just charge my engines up again. So we do trust administration. There's a lot of uptake there, but once the initial work's done, then a trustee can just kind of sit back and let things flow. So make sure you get help up front. And then once you get into the flow of it, then you can sit back. We also offer mediation services. I'm a trained mediator. Sometimes it's just having the parties sit down and have an earnest conversation that is guided by certain rules. And sometimes you can get people to resolution before they file a petition for guardianship. And that helps immensely in the process when you can teach people how to talk to one another. They don't have to like each other, but at least they can come to resolution on the matter at hand, which is taking care of their loved one. And because you took my Barbie doll when I was 3 has nothing to do with it. So, and then we do specialized petitions. On occasion, like you might have a minor that got a settlement, and you decide that that minor wants to go to a special ballet school or art school. You have to ask the court's permission to use that money to do those things. And so those are the specialized petitions that and anything under the sun that you can think of that you want to ask the court's permission of, we can help you get through that process. So anything probate related. The other day I had to go with a individual. The attorney called and said, hey, I need you to inventory a safety deposit box. So we went, they opened the box, we photographed everything and then put it all back in, and I reported to the attorney, and now they're developing a strategy for what's going to be done with the contents. So it's all kinds of stuff, all kinds of stuff.
I've had some experience with a client's family. One of the sons was a probate attorney, retired, and he decided to mediate with his siblings to get his mom, from the farmland to a community. And I was shocked at how successful it was. I never thought the one daughter would be willing to allow mom to move, because her initial statement when I started care for her was, my mom is going to die of starvation in her home. That was her statement. So that the needle turned, and she went and moved into a beautiful community and made friends. So, those are the successes that we see out of mediation.
Yeah. Good. It's a good skill. Good skill.
Yes. Yes. So Charlene, thank you so much. And I'd love to have you back for some of these other topics, if that's okay. I'm going to tap you for some more brain cells, if you don't mind.
No problem. Thank you for having me.
Yeah. And everybody, thank you so much for joining us today. I hope this information was beneficial. If you're looking for an expert in the industry, whether it's in probate, call Charlene and her staff will be more than willing to help. If it's, you know, with your loved one, home care services, or just you need a guide, it's becoming overwhelming. You've realized that it's more than you can handle, or you're looking to, you know, not have to self-educate yourself through this process in the industry, we can help you with that and get things done much quicker. We're knowledgeable about the industry. So thank you and have a great rest of your day.